you.
Okay, get back together on the continuation of Weston Killpack. I had a chance to review some of the stuff Hannah Weston did. Provide some printouts from 2019 and 2020, which helped me understand a little better. To review, the house was purchased in August of 2018, so 2019 would have been the first year for the homeowner exemption. I was reading Weston's analysis more in depth and the statute and what the state tax commission, this was removed by review from the state tax commission. They didn't think it qualified for the homeowners. So that's the standard he has to disprove. I'll give all this for the record. We've got the email from state tax commission showing that the total rent of the Airbnb. On this copy from Weston, looking at the portion of the code, 63701.8b said it does not allow the property upon which the claimant has made an application to be occupied by persons paying in consideration to occupy the dwelling. It's not the only thing. I think that's what you're saying the tax commission was saying. But there are other things that come into play that Weston refers to in his email. And I read it a little different than you did on that. Because if you look, Mr. Killpack has to prove that he, with clear and convincing evidence that this was his home residence. The things that make that difficult, because it actually says in here, utilities is not a claim for that, paying utilities. That doesn't establish residency. It says the primary dwelling means the claimant's dwelling place on January 1st or before April 15th of the year in which the claim is made. He did meet that standard. But then I kind of changed my mind when I saw this printout, because it says a claimant must establish the dwelling to which the claim relates to be his primary dwelling place by clear and convincing evidence, which was a little difficult since he doesn't use it as his mailing address. Files his taxes on another address. And then it says, or by establishing the dwelling is where the claimant resided January 1st or before January 15th, which he has done. And at least 6 months during the prior year, or the majority of the other two, 2 and 3. If he buys it half a year, it's basically 50% plus 1.
He did that as well.
No, he didn't. When he sent this in on 2019, he rented it 31 days in June, starting June 7th. So he hasn't met for 6 months. 2019.
Are you counting lines or the actual dates?
Night dates, but nights.
He didn't meet the 6 months consecutively, but he met it in total for 2019 because they were there after August of that year.
Can I make a
Right
comment
before
here?
the baby was born.
That's-
According to his email,
I was talking,
To
according to Weston's email that he sent us.
I didn't see anything about him being back in August.
Did you print the email?
Yeah, it's attached to all the other papers. I think that's that one right there. Above your glasses. You can stop me.
see the argument for 19, but I can't see it for 20 because we rented it the end of March for 85 days. So that's April, May, June. And then he starts renting it again in September.
Yeah, I have a little harder time with 20, but 19, I'm convinced that, let me look at the, he met, and I still go on Weston's. If the commissioners and assessors convinced by clear and convincing evidence that his home in Idaho Falls is his true, fixed, permanent, and established resident to which he has the intention of returning, and he is not claiming any other residence, then he would qualify under section 63(6).
I'm not convinced by clear and convincing evidence.
Is he
Yes.
declaring the California address on his taxes?
Yeah.
Did
See,
he send the California taxes?
he never sent any of the taxes that we asked him to.
He never, well, he told us that he did not file taxes, didn't he tell us? He didn't.
Not
he-
for
He said
2021 yet.
he said he showed part-time.
He filed for both Idaho and California.
Oh, I
But his
misunderstood
income
that.
tax,
Yeah, see, that's where I'm having a hard
but
time.
that's his income.
Because we're trying to
not his
speculate
residence.
that he's gonna get through dental school, come back and live in this house. There's no way, it's a little different if somebody's, say, assigned to the military for a year or two, and they rent their home. And they still claim that by, that's where they show their residence on their driver's license. Everything else, he shows his residence at his
Mom and dad.
mom and dad's.
And there is a military exemption that they can do
Right.
that. So, I mean, that's,
So
Yeah.
the California taxes, those are property tax in California, or are those income tax?
Other
Income.
tax.
Okay.
And it's a
And-
part year, if you're
Right.
earning money,
No,
which his
Um,
wife may be working down there.
and
has
what
to
I
do
would-
that.
I know several guys that live in Los Angeles, or in San Francisco, Las Vegas, live in Las Vegas, work full-time for LAX Fire. But their residence is in Las Vegas. They fly to Los Angeles, do their shifts, and they fly home. And they come back and forth via air. But their residence, they're in California to work, so they pay all their income tax in California.
Right.
But their residence is in,
And the income taxes are, so if you earn the majority of your money in Idaho, you file an Idaho tax, but you have to file a form that shows a portion
right.
earned in
I just don't know how
California.
that establishes residents outside the state of Idaho. That's,
Yeah, I mean, it's,
so,
he's left too many unanswered questions to make me believe that by clear and convincing evidence, he got accepted to school. I can see the fact, or, based on these nights, that he didn't start renting it till June. You're basically going on his word that he came back in between. There, but he's still got his mailing address at his parents' home. It's not that hard to change.
I'm laughing because our mailing address is my mother-in-law's house.
You're probably one of those kids that,
Because we don't have a mailbox, and I don't want a post office box up there, because you
Yeah.
can't get a lot of stuff in a post office box, so we use. But I'm just saying, there are,
there are circumstances.
and how many circumstances do you stack up?
That's according to the state tax commission, the address he used to file his taxes.
so my question is, in the statute on 67-701 6, it says occupied means actual use and possession. So it doesn't say anywhere in there that they can't have it if they rent it out, but it's got to be actual use and possession. If
Right.
they leave and rent it out and they come back, they have to take possession of that. And in there, it says 6 months and 1 day.
Well,
Right,
but
so the
that's,
question is, was he there for
that's
6
the
months and a
question.
day and 20?
He qualifies for that in 19 clearly.
a little bit.
Yeah.
And the way I read this, it was rented between February and June. October, November, and December. Right? And 20.
Yeah.
But, and the other thing that concerns me is we ask him about the Schedule E for that 366 days. Have a chance to provide an explanation for that. And I said, my dad signed that. This on that form, we should have said X number of days for personal use. Because if you're filing for depreciation, you only get a portion of the depreciation on the days that are not.
This is definitely a difficult one. I mean, it's a little different.
Yeah. So I mean, I can see the argument that he was there for 60. Well, he says he was there for 60 days. But there's nothing to prove that he was. Other than he
You
said,
mean
I
6
came-
months, not 60 days?
Yes,
Yeah.
6 months that I came home and I stayed in my
In
house
19 or in 20.
in 19, but he's trying to make the same argument in 20, saying that all of the times that I'm not renting it, I'm staying there.
Yeah. Does yours have the amounts?
No. this report
When I
doesn't show
look on
that.
here, it has all the amounts on it.
So he didn't provide any.
What are you looking at?
uh,
On there? Yeah, but
because
it's not
supposedly
on
he's
these
down there
ones.
for school year
How
round.
much it charges.
He's going to buy it himself. Sometimes he comes home for the summer.
But it's blocked out in the email.
You know, where's he living down there?
But when you put up on
Does
the
he
phone, it
continue
shows
to
all
rent
of
a place down there? You just move home for 6 months and then hope you get another rental when you're down there.
What about this line in Weston's, you know, therefore, we can take the homeowners exemption statute at face value without having to be concerned of the impact your decision may have on short-term rentals. Instead, this statute deals with terms owners and primary dwelling place.
Right.
So I just don't think it has anything to do with rental. I think it has to do with if he's the owner and if it's his primary dwelling place.
That tells you this.
And
Which I guess is sort of 6 months.
well, but this
Amount.
has to do with rental.
Yeah.
You know, the first part of the statute.
First part,
But it has to do with primary residence and whether he was there or not. And he didn't provide anything very convincing other than an email that says, I came home these periods of time. And so I was in the place counting times that it's not rented in between from time to time. I'm guessing that you're not going to come home for a few days when it's not rented and stay there and then go back to California. He should have a college schedule and when he's off for the summer. He didn't provide any of that. And that's his duty to provide that.
I had hoped for more information. He sent us an email from his dad saying, this is what
We
I
asked
asked
for
taxes.
that.
Even just an email, not a notarized affidavit, which would have been nicer, notarized affidavit saying.
taxes that he terminated his residence in California when he was not living there.
Yeah, the school schedule,
Yeah,
you know, would have been great. And, you know, if his wife or somebody's working part-time, making money when they're down there, so that they have to file in California, which he said that they file. You know, how many days in a year do you claim for California? He, you know, we tried to give him a number of things that he could provide to show that. And the only thing we got is the rental, and he's saying, well, here's the day that I didn't rent it, and that adds up to more than 6 months.
Vacancy is different than occupied. vacancy
This-
of Airbnb. Doesn't necessarily mean occupied by.
Yeah.
I think it's pretty obvious on the large gaps between June and October where there were no rentals at all. But on
But
the,
is it obvious? I mean, you'd think, but from
I
your
think
standpoint,
because that's the summer when he's
you were
not in
saying,
school. But
well, but he hasn't shown anything. You're basically, I think I remember you saying that on the Airbnb, you know, besides the list when it's rented, they can show which are blocked out.
Mhm.
And
Yeah,
You
and-
brought that
and
up, or, well.
No,
you
I
brought that. Yeah, and you didn't provide any of that. You know. So I'm not sure I can do it, and I'll enumerate the reasons, so he has a chance to challenge it if he wants to.
So challenges this, it goes to the court, right?
Does it go to district court or Board of Equalization, the state Board of Equalization?
This one, I think, goes to district court, doesn't it? Or does it go to the state Board of Equalization?
It goes like from commissioners to the BOE and then to the courts.
Yeah, so I
To
think
the
it would go to the
state.
state BOE.
Yeah, because we need to, and maybe the state will
They need,
determine it.
they need to take a look at it, maybe.
But based on,
I believe can't produce new evidence
yes, you can,
for the BOE that was not presented.
oh, you can.
Can.
Yeah, it's a trial de novo. They allow that on our BOEs. You went to the BOE training, yeah. So it gives him a chance to go back and you can give him a list of things that we denied it on. It gives him a chance to take it back to the state. The first one. It's on 63701B.
I can tell you where I'm leaning, just so I still will vote in favor of the 19. I will vote against a motion that denies the 19.
And I'm gonna vote for, so it'll be up to you, because I'm gonna vote for the 19
Okay.
based on these reasons, because he did not provide the clear and convincing evidence for 19. Okay. So it's the property shall be deemed to be the claimant's. Does not allow the property upon which the claimants made the application to be occupied. And it's the part, well, right here. Person. The other one is 63.
Days for March 2nd.
63,701 definitions.
85-day listing will start on March 2nd. which
Right.
may- for 6 months between
8B,
May and October.
definition of primary dwelling.
Yeah, it's May 22nd.
Sleeves. July, August, September.
Dwelling,
Again, the 1st of October. That's 4 months.
yep. You did apply in a time frame. says and. 6 months. He did apply in the time frame. The evidence he sent in showed the beginning of June is when he, or in June is when he started, so he didn't qualify there. His email says I came back, but there's
You're talking about 19.
19.
That's 19.
In September. Offered no proof. But house. From school. Did not. Explanation. Schedule E. "60 days. But she acknowledged, that you filed the Schedule E.
Guess I'd just like you to consider this under number 8. Which the individual is absent has the intention of returning, which is true. A claimant must. What's that?
What has he shown?
Just his word.
Right. But I mean, he's finished school, he could get a job anyplace.
It's just the fact that they bought a brand new house.
Prior to getting into school.
Right. So let me finish this. And then number 1, establish that the dwelling which he claims to relate to his primary dwelling is clear and convincing evidence. Okay, I granted that he hasn't done that. Or it gives him an or. Number 2, by establishing that the dwelling is where the claimant resided on January 1st or before April 15th. He did that in 2019. Okay, and at least 6 months during the prior year.
My problem
He
is.
didn't own it for 6 months in 2018, so he can't do that. So then he has to go down to the majority of the time claimant owned the dwelling if owned by claimant less than a year.
This was owned the full year. So the only one that's applicable is number 1. The others are if it's a portion of the year. 2018, he didn't qualify because at that time you had to file the application for the next year.
Yes,
Change the law.
but
That's on ownership. Of the, he owned it all.
but he resided there the majority of the time they owned it in 2018.
He resided there all the time, but didn't qualify for the homeowners exemption because he could not apply till like.
Well, he doesn't have to, but I'm saying that gives him qualification for 19. The or is the majority of the time he owned it, he lived there.
Yeah, but it doesn't give it to him for 18 because.
No, it doesn't give it for 18. I'm not saying that. I'm saying that gives it to him for 19.
Because this is the majority of the time after the dwelling is occupied, because the majority of the time the claimant owned the dwelling if owned for less than 1 year, or number 3. So it's less than 1 year. The see if occupied by the claimant for less than 1 full year. I still go back to, he's got the burden of proof, which I don't think he's met.
He hasn't. I give
You
you
know, and let's see, I'll go through these again. Stated that he filed. Part-time income tax return. In California. Address. Parents' house. But there, if it's gonna come home for 4 months. Change it. Address and get your mail there. And then, you know, and then I don't know, did he still have an apartment in California? Did he travel up here on the weekends, basically? And was he out of school?
Do we have any proof that about the time he lived there in 2018?
Just the homeowners exemption that they filled out, and it goes in place for 2019, but date of occupancy is August 16th of 2018.
August 16th, 2018.
18 is not
That's when they got the home.
right.
That's when they moved into the home.
But I'm just saying, that's what gives him the qualification for 19, is that he lived there the majority of the time after the claimant first occupied the dwelling, if occupied by the claimant less than a year.
Right. No.
That's given it to him for 19.
If
That's what gives it to him for 19, because that's in the part of the code that says that he had to live there January.
the majority of the time after the claimant is dwelling, if occupied by the claimant for less than 1 year. 2018, he gets it because he's occupied.
Yeah, he doesn't get it for
Right.
18,
But
but he gets it for 19 because he lived there.
okay, that's where I can't, his email didn't provide any proof other than to say I came home in the fall. I didn't change my address. I didn't do anything. I just came home in the fall. That's great to take somebody's word, but that's not clear and convincing evidence, which you have to have. To
I'm
overturn
using the
state
exemption that he filled out that said he moved in August of 2018.
Has nothing to do with 2019.
I disagree.
Okay, you can put that in a dissenting opinion, and they could take the State Board of Equalization. Because I would agree with you if he had provided some evidence, but he came back and stayed there in the fall, other than an email sent in after the fact that this had been the hearing. It has to be clear and convincing evidence on his part. He didn't provide most of the things we asked for. He was very selective in what he sent in. They'll have a chance to take that to the State Board of Tax Appeal.
I'll share my feelings one more time after the motion is made.
So,
My question is, he's stating that he came home on certain days and stayed there. What happens if he didn't stay at the house and he stayed with his parents.
Well, we don't know that.
I know,
That's up-
I know that, but
That's
it's,
up to him to prove.
yeah.
And he hasn't proved it. You know, because he could be staying with his parents and still renting the house when he comes back.
It seemed like one of the Zoom meetings, he did mention that he stayed with his parents.
Must have been the first one.
But I may be wrong, but this is the only meeting I've been to, so it's like,
Mhm.
all of a sudden, I don't.
So here's what I would propose, we deny that on. 63-701B does not allow it to receive a payment. 63-701-8B defines primary dwelling as 6 months plus, the majority of the time there. Even giving him the benefit of the doubt, based on what you're saying, he was occupied in 2018 and started school and rented it in June. He didn't meet the 6 months. Afterwards, he's coming back and saying, well, the days that I'm not renting it, I'm claiming it as my primary dwelling. But he didn't provide any proof. He came back, he was out of school.
Well,
Let me finish.
okay.
The email said he came back in September, but he offered no proof that he was back in the house in September. Or that he was off a semester of school, whether he came home for a weekend, I don't know. Can't go through on the days that it was not rented and accumulate those to be more than 6 months. He did not provide an explanation on the Schedule E, which he acknowledged, that said that there were 360 days rental days, 0 personal use. That's for him to come back with a statement, and we actually asked him to come back and he didn't. On income tax, showing some income in California, failed to provide any of the tax returns. And the mailing address remained in his parents' home for all that time. So I don't think he's met the statutory requirements.
This is where I'm hung up one more time. I haven't been explained very well because I'm trying to understand it myself. If I go strictly on the statute, nowhere do I see in here that it talks about, and please point it out to me if I'm missing it, the income tax return. I don't see that in here, and is where I'm going on 19. Is it says that he has to place clear and convincing evidence. He did not do that. Or establish that he lived there between January 1st and April 15th. He did that for
Right.
2019. And number 3, and I'll go to the first one, at least 6 months in the prior year, the prior year being 18. He didn't do that one, but it gives him another or. The majority of the time he owned the building in the home in 18, which he did, according to when
That's
they
not going,
purchased it.
that's not going to 18. 18
Yes,
is out the
yes, it is, because it says 6 months during the prior year. So the prior year would be 18. And then it gives him an or. If they didn't own it for 6 months, the majority of the time they owned it. That's the part of the statute that tells me that he qualifies for 19.
But if you're using that, are you going to take his explanation on 20?
No,
Okay.
I don't think 20 it works because he didn't live there from January to April in 20.
Living there from January to April allows him to file for a homeowner's exemption. And so he had to live there according to the statute to qualify for a homeowner's exemption.
And he didn't in
changed
20.
You didn't have to. The law has changed now. You can file anytime you
Oh, I
buy
know
the
that.
house.
I thought it was 21, but that included 20.
No, but
That's
once
only
he's
for
established residence, then he, especially when this is taken off by the state tax commission, he has to prove that he lived there and filed the application after it was removed between January 1st and April 15th, which he hasn't established. Because it's,
He can't establish it for 20, because he wasn't there.
and he did establish the first part. But in 19, it says, and at least 6 months during the prior year, being the year that he's asking for. Not 18, because he wasn't there 6 months. He was that. He didn't know, he didn't live in the house for 6
And
months.
then you go to number subset 3, or the majority of the time, if he didn't live there, if he didn't own the home for a year. For 6 months.
Yeah, I disagree, because that's set up for somebody that buys it in the middle of the year and lives there for 9 months. They have to establish that at least 50% of those days of the 9 months he lived there. So it's, 50% of the year. If you,
Just need to vote on it.
okay,
He may have to do it.
yeah. John,
I just keep going to what Weston has saved us the trouble of having to surmise all of the stuff in the code, because Weston, I believe, has done that for us and far more succinctly than I would be capable of doing. So in Weston's summation, it comes down to, is the applicant on the property? Yes. Was it his dwelling place, true and fixed? Which then he goes on to say, and that means, did he claim the homeowner's exemption for a residence in any other property? Which, to my knowledge, we don't have evidence that he's claimed a homeowner's exemption anywhere else, or set any other place as his fixed piece of property. If he's absent, does he have the intent to return? And there, I would say, in my mind, he's provided reasonable proof, not proof beyond a shadow of a doubt, but that's not the standard that this is being held to. Correct?
this is clear and convincing.
Clear and convincing, which is the same as reasonable. A reasonable person,
No,
okay, that's not beyond a shadow of a doubt.
no.
Okay.
Clear and convincing is the second highest. The preponderance of evidence, you can use the reasonable person. Clear and convincing means you have to, I think Weston explained that. I don't know if you were here that day. Clear and convincing, they have to provide proof that convinces us.
It's a pretty high bar.
It's a high bar.
Okay. Here again would be the discussion that we've almost had, that I think when we have these, we should swear people in, because then they're under oath for their testimony. And I think that raises the bar, the level of the testimony, which then when it goes to court, goes to district court, we have testimony under oath as opposed to statements made. I believe he plans on returning. I believe from our discussion, that's my belief, based on what he said.
Okay, now if you're going to use that standard, you're going to have to apply it to 20 and 22, 21, 22. If
Okay,
he
let
claims-
me
Okay,
finish going through Weston's summation here. He's obviously been absent, and I believe he plans to return. Is it his primary dwelling place, and has he permitted or submitted proof to prove that it's his primary dwelling place? Well, in 2019, I think that's pretty well established, because I think he was here to qualify for 2019. 2020, I can't get 6 months out of the division of the space when it wasn't rented for just a weekend. I can't get 6 months out of that. So in 2020, I can't see that he occupied it for the required amount of time in 2020. So I think he qualifies for 2019, but he doesn't qualify for 2020.
okay, but you're taking his statement that he came back in the fall at face value.
Well,
without any proof.
I'm looking at when it was rented and when it wasn't rented for a long period of time, which to me would make me think it was blocked out for that period of time. Is that evidence? Would I be happier if there were more? Yes, but I'm not worried about 20 because it doesn't exist in 20 and 19, I think it does.
Okay.
Um,
So are you proposing a different motion than I am?
I didn't hear a motion.
Well, I outlined everything to basically deny them all because for those reasons.
And I think he qualifies for 19, but he doesn't for 20 based on the information that I have to look at.
I'll make a substitute motion if you want it in
Or
the
amend
form
it,
of
or-
substitute motion. Because I haven't heard a second to your motion, so I'll make a substitute motion that we allow the exemption for 2019 based on 63,701. 8(2) by establishing that the dwelling is where the claimant resided on January 1st or before April 15th, and number 3, well, you've got to include number 1, which says, and at least 6 months during the prior year, which was 2018. Or, he doesn't, just a minute, he didn't qualify that, but it gives him an or, number 3, the majority of the time after the claimant first occupied the dwelling, if occupied by less than a year, which he did from August until December.
But that only applies 2018. And with clarification,
Yeah,
I'm gonna vote against
So-
you with those things and we can talk to West.
that would be my motion, but we
Okay.
deny we deny it for 2020 based on the fact that he wasn't there from
Well,
January 1st, April 15th.
Okay, can you include in those motions the reasons why he didn't provide that?
Yeah, so for
I mean,
2020,
tax returns, everything.
I think it's clear by, again, 701, that number 8, that he has not provided clear and convincing evidence that that was his primary dwelling in 2020. And he does not, under number 2, qualify because it wasn't where he resided from January 1st and before April 15th. That would be my motion. And so we would expect him to make whole for the 2020 exemption and penalties and interest accrued from that time.
And, okay, so you.
I didn't include that in.
Second this motion or
I just want to make sure I have this motion clear in my head.
allowing it for 2019, but disallowing it for 2021.
And
Interest
and
in-
he would have to
interest in
pay the
penalties
penalties and
for
interest.
2020, 2021, but not 19.
No.
Because 19 we're allowing.
We would allow it for 19, but he would have to pay penalties and interest.
I'd second that motion.
Okay, all in favor?
Aye.
Aye.
I will vote no for the reasons stated before, because I don't think we met the standard of clear and convincing based on everything, but he will have the opportunity and should be notified. If he has an opportunity to file it with the state board of tax appeals. I can't remember the deadline on that. That he has so many days. not to
Oh, to file it?
Yeah.
Yeah, I'll have to find that out, because I've never done the BOEs before, so.
Yeah, but get the notice to him as quick as you can on his time to start to file that. So, and then I'll get you my notes if you haven't got them.
Yes,
On the
please.
reasons.
We'll still help you.
Okay. We'll end the hearing.